All right. Good afternoon, everybody. And to keep close on our time schedule, we're going to go ahead and get started. I'm so excited that so many of you were able to join us today. My name is Wendy Venverlo. I am the relatively new Executive Director of NAPSA. For those of you who I have not had the opportunity to meet yet, I just started in August, and I'm thrilled to be here today. Thrilled to be a part of presenting these monthly webinars that we have scheduled. And so this is the third one that we've done in this series, and we have them scheduled as of right now through February. We plan to have the recording of this session on our YouTube channel within the next 24 to 48 hours after it completes. And you can find the first two videos that we had done on there right now. We do have one session. I want to just kind of plug next month's session is December 3rd, 1 p.m. Central Time, which is responding to pretrial compliance and non-compliance. And so most of you, I'm assuming, have seen that. And if not, I will be sure to drop the registration link in the chat. But anyway, without further ado, I am excited to present and welcome our friends and colleagues from Allegheny County, Chris and Sanjeev.
Good afternoon, everybody. I'm Sanjeev Betaroy. I am the Deputy Director of Evaluation here in the 5th Judicial District of Pennsylvania within criminal court. So we're up in Allegheny County, aka Pittsburgh, Pennsylvania. I've been working with our pretrial department for over 6 years now, handling evaluation, but I also support work in the probation space as well as the court space for issues like court processing and assessing the outcomes of those who are incarcerated. So happy to work with my colleague, Chris. We're going to be talking about supervision dosage today, and in the realm of pretrial supervision. With that, I'm going to let Chris introduce himself.
Hi, everybody. Thank you for joining. Thank you for attending. Thank you to Wendy for hosting this. My name is Chris Shanley, and I am the director here at Allegheny County in Pretrial Services. I've been the director for about 1.5 years now. I was the third person who was hired into Pretrial Services back in 2007 when we created Pretrial Services. And I come to Pretrial Services with a background from adult probation. And I was a probation officer before I was a supervision officer. So when we started pretrial, my frame of reference was, how do you supervise people in the community? And unfortunately, or fortunately, my frame of reference was, how do you supervise people in the community, was very similar to how we did it in probation. Thankfully, over the past 17 years, that frame of reference has changed. So we do it completely different now. I'm very proud to say that. And so I think we can get started, because I think what you're going to see is probably going to surprise you a little bit. So today, what we're here to do is we're going to talk about how pretrial supervision and how we supervise defendants in Allegheny County. It is, I don't want to say it's unique. It's probably very similar to what a lot of people do throughout the entire United States. We'll talk about how we supervise them. I will also talk a little bit about what we expect from our supervision officers. Okay, when that person comes in who is told to report in person and they sit down across from that officer, what are we expecting that officer to talk to them about? What are we expecting that officer to get out of that person? We have about 2,500 people on supervision right now, and we'll explain the levels of reporting. The next thing we're going to talk about, different levels of supervision. We have people who are reporting by phone to our office. We have people that are reporting in person to our office. And we have people that are on electronic monitoring. And that electronic monitoring, we use it as a very, very, very limited resource. Okay. It's very limited. The high level supervision, that's who we're putting on the high level supervision. Most importantly, does reporting frequency equate to pretrial success? And I think that's why you guys are all here today. And towards the end of this presentation, when I turn it over to Sanjeev to talk to you about the data points, I think some of you guys will be pleasantly surprised. The second part of that is, how does pretrial supervision compare to other bail types when it comes to pretrial success? So the people who are given monetary bonds, people who are given ROR bonds, people who are given non-monetary bonds with condition. Sanjeev had the ability to look across all of those different levels of bail to decide, to show you that most people, if you leave those people alone, will do just fine. The other thing that I will talk about when we talk about the levels of supervision is, are we doing a person an injustice by making them report too frequently? Okay. So that's one of the things we'll talk about. Well, and the last bullet point is, what can you take back to your jurisdictions? In Allegheny County, we've been up and running since 2007. I like to think we run a pretty good pretrial program. But every time we go somewhere, whether it be NAPSA, whether we go to the state of Pennsylvania pretrial conference, I look to take something back to our agency that we can improve on. So that's what I want you to do here, is I want you to listen to what we have to say, think about what we have to say, but more importantly, if there's something that we talk about over the next 55 minutes or so that you think is important, that's something that you can take back to your jurisdiction, take something back. Try to implement it. See what you can do with it. Okay? So you can go one more, Sanjeev, because that's... So here we are today in Allegheny County. Right now, locally, we have about 1.2 million residents. Okay, we have a locally validated risk tool. Okay, our latest revalidation was in 2020 and implemented in 2022. Our risk assessment, our locally validated risk assessment, looks at three different things. It looks at FTA rates, it looks at new criminal activity rates, and most importantly, something we've done since 2022 is we look at new violent criminal activity as well. Okay, so our locally validated tool looks at those three things. Okay, in Allegheny County, our pretrial services department, we work 24 hours a day, 7 days a week in our county jail. Our county jail is used as a central booking. So anyone who is arrested, they can be brought to the county jail, and we will implement a risk assessment. We'll make a release recommendation to the judge on every new arrest that occurs in Allegheny County, along with every bench warrant. So if somebody's picked up on a bench warrant, they will come through our office. We will apply the risk assessment to that person, and we will make a release recommendation. Okay. What I want to stress to you is this, is pretrial services, we make a recommendation, but the bail authority, whether it be the MDJ or the common pleas court judge, they're the ones who make the decision. And this is maybe for a whole different topic, but when we look at recommendations compared to what other people get, sometimes they're not aligned, if I can just say it that way. The PSA we use for our MDJ courts, the magisterial district courts can notify our office electronically that they have a person in their jurisdiction at their office, and they're going to be conducting an arraignment in their office. This generally occurs during normal business hours, and what that judge can do is contact our office electronically, ask for a risk assessment, and what we will do is we will send that risk assessment recommendation back to the judge, all within about 25 minutes to a half an hour. Okay. The reason why we use the PSA at the MDJ courts is because the PSA does not need the interview. Okay. Our locally validated risk assessment, we need the interview component of that face-to-face occurrence with the person. Okay, so we're doing two different sets of risk assessments at the county jail, our central booking. We're doing our locally validated tool at the magistrate's office. We are using the PSA. Okay, in 2023, we did about 20,000 total bail investigations, And correct me if I'm wrong, Sanjeev, but I think we are on pace to do about the same this year in 2024.
That's correct.
So we are relatively busy as a central booking location. We have 12 bail investigators that work 24 hours a day, 7 days a week, 365 days a year. And they're not very happy that they have to work on Thanksgiving or Christmas, but we move on. Our locally valid risk tool, as I stated earlier, it's going to give us 3 different scores. Okay. It is going to give us a score for new criminal activity. It is going to give us a new score for new violent criminal activity. Okay. And it scores the failures to appear. Okay. All of those are probabilities. Okay. There's 7 different probabilities, and I don't want to get too far off the subject into risk assessment probabilities, but basically what it does is gives us a score from 1 to 6 on each of those. How they coincide with each other creates the release recommendation. Okay. New violent criminal activity usually will bump up the level of supervision. Okay. So if in our new violent criminal activity, someone scores a 5 or a 6, okay, meaning that they're on the highest part of that tier group, what will happen is if that person is coming out report by phone, that will automatically bump that person into report it by person. Okay. So it gives us internally, if we identify that person as someone who is highly likely to commit a new violent criminal activity, we will bump up the level of supervision. Okay. That is something new that we've implemented since 2022. We are seeing a lot of violence, crime here in Pittsburgh, here in Allegheny County. So those are the bump up levels. We also have the ability to have supervisor overrides. So if someone is coming out very low supervision, but we feel that it doesn't coincide with the release recommendation, our bail investigators have the ability to pick up the phone, call the supervisor on call, and talk to them, make an argument, make a reason as to why they feel that the level of supervision, the recommendation doesn't coincide with what it really should be. We see that for things like the statutory sexual assault cases, the rape cases, the child pornography cases, where those people generally have very, very limited criminal history, but they're the higher crime type of people that we are seeing. So we do have the ability to increase that recommendation if they talk to a supervisor and the bail investigator can articulate the reasons why they think it should be bumped up. On the flip side of that, we also have the ability with supervisor overrides to decrease the level of supervision as well. Okay. So our supervision unit right now is we have 2 pretrial electronic monitoring coordinators with 4 probation officers that handle field work. So our pretrial electronic monitoring is shared with adult probation. Okay. We have 2 EM coordinators in this office, and their goal is to take court orders in which somebody is ordered onto pretrial electronic monitoring, take those orders and work on getting that person released into the community on house arrest. Okay. We have 2 people that are doing that on a full-time basis. The MDJs, the lower court in Allegheny County, does not have the ability to put somebody onto pretrial electronic monitoring. They can make the recommendation to our office, the reasons why they feel that. Once they make that recommendation, we will look at the case, we will look at the recommendation of our risk assessment, and we will take that case to motions court. A common pleas court judge will handle that bail hearing, adversarial hearing, DA, pretrial services, and defense attorney. Okay. So when we started pretrial services in 2007, and we gave the MDJs the ability to put people on house arrest, our pretrial numbers went from about 65 people to up over 400 in about 6 months. It was highly, highly overused. People would go to their preliminary hearing, and the case will get withdrawn. We have 7 pretrial supervision officers that handle those medium people, those report in person people. We have 1 case manager who handles the low supervision. And everybody, regardless of the level of their supervision, is going to get a text update from our third-party text reminder person. Okay? So how do we define pretrial success? Okay. I want you to think back to what is bail. Okay. Bail is you want that person to appear at all court appearances, and you want that person to remain arrest-free. Those are the goals. Okay. On the top, reporting in person, reporting by phone. The reporting in Allegheny County is secondary to going to court and remaining arrest-free. Okay? It is secondary to going to court and remaining arrest-free. Being a supervision officer for about 4 or 5 years and sitting across from a client that was struggling because they just got arrested, they were released from jail, they've missed work, and they have 1 day off the following week to take off. Do I want that person to go to court, or do I want that person to report in person to this office? As a supervision officer, now as a director, I want that person to go to court. Going to court is more important than reporting in person, reporting by phone. I'm not saying that those things aren't important, but when you deal with clients who are just recently arrested and they only have 1 day off, I'm going to say, hey, go to court. If somebody doesn't report by person, somebody doesn't report by phone, we have the ability to send updates to the court. We will send letters to the MDJs. We will reach out to the person. We'll call the person. Our goal is to get that person into compliance. But the biggest compliance is they go to court and they don't get rearrested. Okay? That is a complete different mindset that I came from adult probation. If I sent somebody a letter and said, your initial interview is on November 12th at 2:18 p.m., and that person didn't show up, I was going to my supervisor and asking for a warrant. Now, I want that person to go to court. Okay. Abstinence, drug use, I'm going to venture to say in the past year, we have drug tested less than 50 people total in the past year. Okay. The only way that we will drug test is if we have a specific court order from a judge telling us that we have to. When we first started pretrial services, again, it was one of those things that was completely overused. We went from probably over 400 drug tests in 1 year down to less than 50. Okay. Very, very minimal. No victim contact. We reiterate no victim contact. One of the things our bail investigators do at first appearance when they're talking to that person in the jail, if there's a victim in the case, say it's a domestic violence case, one of the first thing our bail investigators are going to do is say, if you are to be released from jail without having to pay money, is there another location that you can go to? To follow that up, that bail investigator is going to reach out to that person and say, hey, Chris Shanley was arrested for domestic violence. If he were to be released, could he come to your house? Could he stay at your house? We want to keep victims away from each other. Okay. And again, I already talked about appearing for the court appearances and remaining arrest-free. So that's what we look at when we determine pretrial success. The biggest two are the bottom two. Our levels of supervision, our low supervision, it costs the person $48 paid to CDI, BTM Software Solutions. If you are in the state of Pennsylvania and you have anything to do with courts, you know who BTI or CDI and BTM was. They are an agency that helps probation departments, pretrial departments, what the person has done is they are charged a $48 fee. And I will tell you this, if the person does not pay the $48, we do not violate them for not paying the $48. Okay? If they don't pay the $48, they will still have the ability to log in, to call in, to answer their questions. Okay? If you look, there are 7 questions at the bottom. So the person will call on every other Tuesday. They will answer those questions. And if one of those questions gets flagged, we have one case manager that oversees those 800 or so cases. And what she does on every Wednesday, she will get a report showing everyone that had a flag. And every one of those flag cases, she will pick up the phone and she will call that person back and she will talk to them about that. Okay? But again, I want to stress, we do not violate the person for not paying the $48 fee, and the person can still call in, answer the questions, and be in compliance. Okay? Our medium supervision people, 10 o'clock first business day after release. Okay? What we do is everyone gets a pink contract, says if you're ordered to report in person, you will report to our office 10 o'clock the very next day. Okay? We ask people to report about every 2 weeks-ish. Okay? What we do is we have non-specific reporting dates. What we will do is we'll give the person a date to appear by, and it's generally a Thursday. We will say, you need to report by Thursday, December 16th. And I don't even know if that's a Thursday or not. But that person can come in any day during that week, Monday through Thursday, walk into our office, sit down across the table from a supervision officer, talk to that supervision officer, talk about their next court date, talk about where they're living. And it doesn't have to be the person's specific probation or supervision officer that is actually seeing them. Okay. The other thing is this, is we have collectively 7 supervision officers that have caseloads very similar to probation. Those caseloads are for those officers to send letters to the people who are not reporting, to notify the court, to stay in contact with their cases. But when they come in, that person comes into our office, they can be seen by any of the 7 officers who are there, seeing people, going over, asking the questions. Okay, when is your next court date? Do you see any issues with you showing up on that date? Are there issues with transportation? Are there issues with childcare? Are there things like that? Because we want them to show up for court. Okay. In 2007, when we started to create our supervision, anytime we wanted to reduce a person's level of supervision, we went back to the court. Okay. And after a couple months, our then president judge at the time said to pretrial services through an administrative order this: if pretrial services wants to reduce the level of somebody's supervision from in-person to report by phone, we have the ability to administratively do that. If we want to increase the level of supervision and say, hey, they're not doing well by reporting by phone, we now want to bring that person in to report in person, we have to take that to the court. We have to have a hearing. They're represented, the public defender, DA. It's an adversarial hearing, and we actually have an actual bail hearing on that. So if we want to reduce the level of supervision, we are okay to do that. But if we want to increase the level of supervision, we have to have the hearing. Okay? So that is where we stand with reporting in person, reporting in by phone. And I'm going to turn it over to my colleague, Sanjeev Betaroy, because now he took all of that information and is now going to talk to you about why you guys are all here. So Sanjeev, I'm going to turn it over to you.
Thanks, Chris. So, as you folks have seen, we have a pretty thorough, thoughtful structure, and I'm sure other jurisdictions have similar structures with a lot of diversity in terms of how you can work with someone pre-trial. But I think bottom line is we have to continuously monitor and assess whether or not what we're doing makes sense and there's outcomes. So what I've done is I've looked at a cohort of folks who are released from, not even released from our jail, who were given pretrial supervision or given some kind of bond in order to see how effective both the type of supervision was as well as the contact frequency if they were assigned to pretrial services. So with that in mind, we looked at just over 23,000 investigation episodes between September of 2022 and around mid-August as we were prepping to meet you all in New Orleans, and unfortunately didn't get that opportunity. And just like a wink and a nod to the color scheme of Mardi Gras, it's 40 some degrees in Pittsburgh, so I really am cherishing my memories of New Orleans. But hopefully this is brought to wherever you are right now in terms of that spirit. So anyway, we looked at folks where the actual case was completed. So it was essentially an exit cohort for pretrial. So whether it was our general trial court or cases resolved at our minor court. So, some of our folks, they never were brought up to what we call big court. So we looked at that full-on exit cohort. And of those, there were about 23,000 records that we looked at. So, if they were never supervised by our pretrial office, we looked at whether or not, what was the initial bail type. So obviously when you have pretrial failure, and even if you don't, one can get multiple bails over the duration of a pretrial period. So we started with what was the initial one given. So if it was money bail that was eventually turned to supervision, we grouped them with pretrial because they were eventually served by our office. Now, on the other hand, if it was money bail that was denied bail, we would categorize them as a money bail because they were originally given cash bail. And then for pretrial, we organized by the highest intensity that we worked with that individual. So a little bit of a difference. And, obviously when you're conducting studies, methodology is important, but I just wanted to be upfront with what I did in the event that other analysts are here and want to replicate this work. There's obviously caveats, you can take this work. So, we did some grouping by the dosage of contact. So it was based on completed contact. When you call someone on the phone, and this is really theory, or not even theory, but practice from probation, you can measure the attempted contact versus the completed contact. For my purposes, I was trying to gauge whether the actual interaction is what made the difference for an individual who was supervised by pretrial services. So even if our officers were trying, and I want to give them credit because they often do, particularly when you have phone-in people calling folks all the time, this is strictly an analysis of whether or not one who received the service, received that contact, what was the impact, if we can draw that conclusion. So while we're very mindful that our folks are constantly trying to reach people, I am only evaluating based on the completed contact. So like Chris mentioned, we measure failures to appear and new criminal activity as determined by a new criminal filing or a new arrest. So we looked at whether or not essentially there was pretrial failure during the pretrial period. For this analysis, I didn't specifically look at new violent criminal activity, but we have the capacity to do that as well. That's an easy next step for me to do. So when it comes to how we grouped it, just as I said before, we did it by the principal bail or the highest pretrial supervision group. And then for pretrial, you not only get the highest group, but how often we contacted those people. So you'll see in a moment, that we did some stratification based off of contact frequency. So looking at outcomes. So first thing we did is we looked by the actual group level. So without considering contact, and I'm not going to go through every group of these bar graphs, but I'm going to leave it on for about 1.5 to 2 minutes as I talk through some key findings. So just as a heads up, if you're looking, the blue bar / leftmost bar is complete pretrial success. And then the middle or orange bar is those who completed without a bench warrant for failing to appear. And then the green is those who completed with green / right, I should say, those who completed without a rearrest during their pretrial period. So what I've done is I've grouped obviously low, medium, and high, but really grouped pretrial together as any supervision. And of the any supervision group, we had 10,547 episodes that we analyzed. And then I isolated the ROR, which is, report as upon recognizance or without bail condition, essentially, unsecured or nominal bonds, where there is no posting required, but there is a bond set, and then other non-monetary bonds, which is, other conditions such as, just a no victim contact, for example, falls into that, or if there's a treatment requirement, but you're not required to report, that follows into the other non-monetary, and then monetary bail, and then all cases together to look at the outcomes. So in our jurisdiction, over this time period between fall of 2022 into summer of 2024, the the highest number of people received pretrial supervision at some point. So it's a positive for us in the sense that what we are doing is being used by the judges. It's being, I would wager to say that it's something that our court believes in. We still have a fairly high share of monetary bonds set in Allegheny County, but this we have seen in the last 4 years this diminish. And I just wanted to highlight the comparison between the any supervision group, that first black box, and then the second black box, which has the monetary and all cases. So you can see that relative to the totality of cases, our office and our pretrial supervision, it's about the same as total. And I think that's just because the largest share included in all cases is pretrial supervision. So there's a slight difference in terms of complete success, but it's not really statistically significant based on testing that we've done. And then we have identical percentage points for those without a warrant and those, who are not rearrested. And that's largely because, we make up the majority of cases.
Sanjeev, can I just interject real quickly into something I didn't talk about when I was in the state of Pennsylvania? It is still legal to give somebody a money bail. Okay. We as pretrial services, we've not made the recommendation for any money bail since 2007. However, it is still legal for them to use money bail. So if you see the monetary bonds, we do not make that recommendation, pretrial services, but it is still permitted by law for the MDJs to use that.
Right. So I think other jurisdictions, that's no longer a reality. But yes, in Pennsylvania, we still have that. But I think the bang for your buck in the analysis here is the fact that compared to particularly money bail, but also other non-monetary conditions, as well as our nominal group here, our office is outperforming those folks, which is encouraging. And we've done various iterations. Like, this is a very high level analysis, but we've done iterations where we do controlling for things like risk factors. So I think to be extra clear, when I'm talking about low, medium, and high on this slide, It's the grouping that pretrial services has assigned, and it's not necessarily our local risk needs assessments grouping, if you will. So there's an intermediate step. So one is assessed by pretrial via the investigation, and both the assessment instrument as well as the pretrial office offers the assessment instrument. We'll focus on that, gives risk for the new criminal activity, the failing to appear, as well as new violent activity, as Chris mentioned. That's not necessarily what we're capturing in this slide. We're capturing the supervision assignment level. So low being the phone, medium being the report in person, and high being our electronic monitoring. So I just want to make clear that distinction that we're not using our tool risk here, we're using our supervision assignment risk, which, while they overlap a lot, they're not the same thing. But I do bring that up because we do have risk scoring on our monetary population, on our other non-monetary population. So when we've done controlling of factors, by risk factors that we score, we see that if you even controlled our supervision population against the monetary folks, so you're doing an apples to apples, similarly risk, similarly charged people, that we are outperforming them. So it is encouraging to see that something about the way that we are working with folks, at least at the high level, it appears that we are doing a more effective job than just leaving someone to monetary bail. I think this is space, as I don't want to get too ahead of myself, but this is space where there needs to be further investigation and further research being done, because I am making the conclusion that our office at a high level, just being involved with it, seems to be more effective than other bail types. So I'm going to stand on that until I welcome external folks into our jurisdiction, because we're a pretty open book here. Just before I move on to the next slide, though, if you're
Yeah,
wondering
David.
hold on, Chris, one
Yep,
second.
yep, yep, yep.
As we why our high group is so likely to succeed, remember that's our EM. So these people are banded and they're, unlikely to go anywhere in the moment. We found that in the pretrial space, even though I know there's conflicting research about the effectiveness of electronic monitoring. In our jurisdiction, in the space of pretrial, we do see that failing to appear in new criminal activity is relatively low, and it's an expected outcome. So I want to also just a wink and a nod to something Chris went through, though, is that our population is increasing. So we do expect some more failure based on, I think, the changing complexion to who's included in there. Chris, why don't you weigh in?
So one of the things I was answering a question in the Q&A, and what the question was is why does high do so well? And you answered that. So
Yeah.
So thank you. Just real quickly, in the state of Pennsylvania, there was a Supreme Court decision called the Talley decision that changed a lot of bail decisions here. Real quickly, the Talley decision in the state of Pennsylvania basically says that the Commonwealth cannot rely on the affidavit of probable cause alone to determine dangerousness in denying somebody's bail. So that also plays into why our EM numbers have gone up dramatically. So the court will no longer deny somebody's bail if they believe them to be dangerous. They're more likely to put that person on pretrial electronic monitoring. So that Talley decision changed a lot in Allegheny County. So.
Yep. And I'll say our final point on this too. I do want to touch on the fact that the ROR group, those without any restriction, they do perform quite well. So I think it makes natural sense based off of the theory of risk, the people who are being screened as low risk and being, I suppose, validated by our judges as low risk by virtue of their initial bail being, essentially, no conditions on their bill, that we we're doing a reasonable job, and I'm speaking a little vaguely just because I think there's more you know testing to be done on this, but we're doing a reasonable job as a court system in identifying people who will be successful without intervention. Could it be better? I think so. I think perhaps people who are in our low group could do fine without any intervention, without our reporting by phone. But it's an interesting thing that I want to be mindful that we're not like the ultimate secret sauce, but we are, I think, at a high level proud of our outcomes. Let me move on to just the supervision version. And I apologize, it's a lot of information to digest, and I know we only have like 20 more minutes. But what we've done here is now we've taken just the pretrial group that you saw on the prior slide. And we just did the distribution of how often we were contacting folks. So rather than going through all of these, I think the major takeaway that we have is or one of the major takeaways is that there are a lot of people that we never get in contact with. So for the low group, about a third of them we're never seeing. Now medium, about 41%. So of all of the groups within the medium threshold, the highest that we have in terms of contact frequency is people that we never have successful contact with. So I think that's an important kind of conclusion or finding in and of itself, where it's like a lot of these people are never really served by our office. And many of them, I would wager to say the majority of them, but we can do further investigation, are actually doing fine. So I think that's an ultimate conclusion we have later on in this, is that most people released pre-trial do fine, and they don't commit new crimes, and they don't fail to appear. So now there's obvious rails we put around that, but I mean, just mathematically, that's the reality. So it is uh pretty interesting to note that, we still miss in total about 38% of the folks assigned to our office. But I think it's encouraging to first state that, there's no, very rarely, I would say, would there be a penalty. We're trying to help people get to court, and, whatever we can do, avoid an arrest if they're not going to engage in our office, absent some, exceptional circumstance, we are not going to further disrupt their lives. But just moving through this quickly, about 34% of the total cohort, so I'm now reading the bottom bold totals, received 1 to 2 contacts, regardless of their risk group. About 18% received 3 to 5 contacts, and about 9% received over 5 contacts. So, and you can see at that group, there's a high level of electronic monitoring folks who received such contact. So it is pretty interesting that, like, when we do the analysis and we see this distribution, most of our folks are not receiving that many contacts, particularly the report in person. But let's see if it actually makes a difference. And so, again, I apologize for the breadth of information here, but you can see that, again, if you go to the very right of this, it's the same groupings that you had seen before in terms of the overall success rates. And then moving leftward, if you will, by the number of contacts that, what is the success rate as defined by total success, not getting arrested again, and then not getting a warrant for failing to appear. So for me, the thing that I gravitate most towards, because it's the one that I think is most on the table to change, is what I've put in blue, this medium group. And so it's interesting to see just the trend here, where those who are never successfully contacted, again, the majority of them are doing well. So 3 out of 4 are going to complete without any kind of pretrial violation as defined by arrest or failing to show up for court. But then, this is of all the groups, outside of the direct comparison of complete success between never contacted and over 5 contacts, they did not perform as well as those contacted 1 to 2 times, and they did not perform as well as those contacted 3 to 5 times. So perhaps there is more we can be doing to proactively re-engage these folks pre-trial to avoid additional kinds of violations or failures, if you will. But I think it is pretty interesting, though, that those who are contacted the most within the medium group are least likely to succeed relative to 1 to 2 contacts and 3 to 5 contacts. Without doing too much investigation at this time, I wonder if there's more nuanced risk that we could do here to analyze this population. In plain English, I think the fact that if you remember what Chris had said earlier, that you can essentially earn step downs, right? Like if you're doing well and you're showing up, then we're more likely to say, all right, report, now instead of every 2 weeks, every month, and then we're just not going to follow up because you're showing up for court and you didn't get arrested. To me, those who are contacted over 5 times, there's probably, perhaps there's a reason. I mean, I don't want to draw too many conclusions, but perhaps there's a reason that our office continues to work with these people. So I think again, this is, speaking to areas where there's further work to be done. I will say with the we did some significance testing across the within each risk group, and particularly for low risk and high risk, there really was no statistically significant difference between whether we saw them once or whether we saw them over 5 times or 3 to 5, anything in between. So I mean, yes, I'm most interested in the medium group, but there's clearly some kind of perhaps there's nothing to be done, but to me there's a research question at minimum as to what can we do differently. The success rates are very good. I will also say that they are very good. So as an evaluator, sometimes it's hard to, see the forest for the trees, if you will, in that again, most people are doing well, and we're trying to tweak things that are doing quite well at an objective measure. I would, invite Wendy in the field to definitely speak on that at some, in some regard, in the sense of, we are highlighting some positive outcomes. We're trying to get better, but we are again open to working with external folks to validate some of our internal conclusions. But yeah, because medium has this variability, and you see that when we get to essentially for some of these groupings, the more we contacted them, the worse the overall rate was. So at least when it comes to complete success. So how do we wrap that up in a bow, if you will? So in terms of the thoughts on these outcomes, so again, I can't overstate that, we did perform better than cash bail for similarly risky individuals per our instrument. So yeah, while we didn't highlight that, we highlighted that at the highest level. We know this to be true based on the work that we've done. I want to give a shout out to Rand Corporation, who's helped us look at this in the past, both in the space of racial equity, but also in the space of assessing the impact of attorney and defense representation at our first appearance. So independent of that work, the Rand Corporation has also looked at how various bail populations have done, including monetary bond versus pretrial supervision. So we've had some external validation on our conclusions. Similarly speaking, supervision is outperforming other non-monetary conditions and releases. So there's something to be said. There's more work again to be done to make sure we're comparing similarly risky people, but also if it's like, what exactly was that condition? Is there more grouping that we can do within the pretrial group versus those other conditions? Like, is it apples to apples to say like one who receives a full-on report in person versus just don't go back to that one target? Like, is that a comparable kind of comparison? I'm sure more sophisticated analysts have thought on that. So I'm definitely willing to hear that. And then for most of the cases, dosage did not correlate to improved outcomes. I think we see that with the low and high, it's pretty clear there's no statistically significant difference. And then within the medium, you see some worse performances for that most frequently contacted group, outside of obviously those who we never got in touch with. And I think that last point is what these final bullets speak to. So like obviously it seemed that particularly for the 1 to 2 and 3 to 5 group, some contact was at least slightly better at a very, very high level than those we never got in touch with. Um, and then I think where the space and where the field really should think about this is what is quality of contact? So we talked about the model, we talked about how we engage, how there's a lot of customization, but what are we actually talking about with people? And so, whereas I'm going to continue to move on as we hit our final 10 into closing thoughts. But one of the things that, Chris had made mention of is this office in Allegheny County really had a legacy of probation supervision. And in many ways, we view that as, probation. There's just more conditions that, at least locally, need to be enforced, right? So in order to be in compliance and to successfully complete your probation, you have to satisfy a variety of conditions. Whereas with pretrial, we are very, very focused on those two outcomes of not getting arrested and showing up for court. So, however, is there stuff to be learned or something to be learned from probation? So, not to be completely out of order, but particularly, I'm going to go to this third bullet point first. To improve, because it does bother me, something about seeing people more than 5 times for medium supervision and them having the worst outcomes. Like, does the risk needs responsivity model have a place in our pretrial department? So do we need to do additional assessment? We do the initial bail assessment through our risk assessment instrument, but any kind of, we have cases that pre-trial are almost a year, in terms of duration. It's an opportunity to work with people without, the hammer of putting more conditions on. But is there more we can learn from probation in that space? And then really, like, we have really viewed ourselves as a justice-based agency. So what kind of social services do we consider? Chris and I have debated this and disagreed upon this at various points. And like, I think on both sides, there's definitely points. Like, supervision officers shouldn't be responsible for the entirety of one's social needs. But at the same time, like, can we be better? And then, I think others may say, like, over servicing people can be traumatic and can be too much. But when you see a demonstrated need, we can just be another touch point. Like, we do a reasonable job at providing resources, like connections to resources in terms of, hey, this is what's out there in the community. Is there more of a handoff that's necessary? I'm not sure about that, but it's something that we've considered here in Allegheny County. Just to restate it again, we did do well against typical alternatives. So as we hammer away at the thought of whether or not, cash bail has a place in Pennsylvania, at least in our jurisdiction, we can highlight and we have the means of identifying that people who are similarly risked that are served by our office do better than the money bill population. And again, we just have to think about the quality of the contact, because just the increased dosage does not necessarily increase or improve outcomes. I think I did touch on some of those reasons as to why that may be, which is maybe there's a gap in the particular drivers of risk that we're missing. Like, I also want to be very, like, respectful and intentional to the people doing the frontline work. There's something that, as I look at 23,000 records in isolation, okay, there's perhaps not a data conclusion, but then an individual, a client, walks through the door, and the officer who is an expert and who we view as experts may be able to see, all right, I think I need to work with that person. That's where I think that third point comes into play. How are we working with that person? What more can we do as an office? What I love about our model is what Chris highlighted, which is that there's one can share the caseload. When the officer is out meeting people, it doesn't have to be your person. Now, do we rethink that if it's more effective to have that consistency? who knows? I think the way that we're structured right now, it gives people, whether it's the staff, whether it's the person, reporting, a little bit more freedom in terms of I can, not have this intrusive experience. I also think that our officers would be amenable to doing a little bit more in terms of engagement. I can't understate this though, that most of these folks who get out, they're doing well. They do not have a transgression. No matter what you measure, they just, their pre-trial outcomes are good. Even our highest risk people, independent of electronic monitoring, they're doing well. I would say that perhaps there's more space that we could be doing with those who are receiving money bail. They have the worst outcomes based on the findings that I had. So to me, it's an argument that perhaps our existing model is, positioned to help those folks. And I think this is a perfect time to transition to other questions and maybe even comments. Like for those of you who have pretrial services and who have the ability to do this kind of work, have you experienced similar things? So with that, I definitely want to turn it over to you folks, and I'm not sure if folks can comment, but definitely through the chat, would love to hear about that. We'd also take any questions at this time that you may have.
Sanjeev and Chris, it looks like quite a few people have put some questions in the chat, and I know Chris has been actively answering them. We also
Yeah.
have, and so that's been the main way that we have been fielding questions. If people want to put those there, especially since we only have 3 minutes left, I don't know that we have, unfortunately, the time for a big discussion right now. Though maybe what we can do is have a continuation of this if we were unable to do that.
Mhm. We'd be more than amenable to do that, and I definitely want to put the survey link in terms of and invite people to weigh in on this. But yeah, I think Allegheny would love to continue this and make this more of like a discussion with people, a little bit more democratic as well, because I think this is where the field is going, right? Like we would love to, in many ways, rethink what pretrial supervision looks like if it can be better. We stand by our outcomes, but we're always striving to be better.
Just in the last couple of minutes, I wanted, as I see that some folks are obviously needing to drop off, probably for meetings that are occurring. Just want to say again, thank you so much on behalf of NAPSA for attending. This was wonderful. It looks like we have a great amount of interest, maybe again, to continue this conversation, to talk more about pretrial supervision. And so anyway, grateful to have you all today. And for those that need to leave, hopeful that you have a wonderful day. And then it looks like perhaps Chris and Sanjeev would be able to answer a few more questions in the chat. So anyway, thank you so much.